All right, hello class. We're back at it again. And this time we'll be going a little bit further into proving defective conditions. And especially we're going to talk about types of defective conditions shortly. And then we're going to go back to this risk utility analysis that we discussed in the last section, in the last session, when we talked about the Ford F-150 pickup in Riley versus Ford Motor Company. All right, so we're going to go back to that shortly, but in order to understand that additional discussion, I'm going to discuss the types of defective conditions that a plaintiff may prove, right? And there are three general types of defective conditions that can be proven by a plaintiff, and those are manufacturing defects, design defects, and insufficient or inadequate warnings, right? Manufacturing defects, design defects, and inadequate warnings. The inadequate warnings, I'll get to in the next session. I'm going to focus on manufacturing defects and design defects in this quick session. So a manufacturing defect, if something has been manufactured improperly, for example, it's been put together incorrectly, or a step was missed, wasn't properly inspected, wasn't properly tested, some process was not done correctly, or alternatively, perhaps it was damaged, right? Or the product as it is, right, is otherwise flawed, right? That is what's known as a manufacturing defect, right? So those three categories: damage to the goods, right? The product is flawed in some way, or it's been improperly assembled, right? And that can happen in a variety of ways, like I just said. They could have failed to test it, like a screw, the wrong size screw could have been placed inside of the goods. So that is one type of defect. And the test for a manufacturing defect is relatively simple, right? Or at least on one level, right? Does the product comply with its specifications? Does it conform to its blueprint? Is it as it was designed to be, right? If it is not as it is designed to be, then there is a failure to sell goods in compliance with the specifications. And you may have a manufacturing defect. And if that manufacturing defect again causes the injury, then you can't have a recovery. So Kevin Schmoody purchases an 8-foot step ladder. He uses it to install radio frequency shielding in hospital rooms. While Schmoody was standing on the ladder, it collapsed and he was seriously injured. He filed a lawsuit against the ladder's maker, which was Tricam Industries, and he alleges a manufacturing defect. So he's saying that that ladder, right, was no good, right, as you gave it to me, as it was produced. Experts testified that when the ladder was assembled during manufacturing, the pre-existing holes in the top cap for the ladder did not properly line up with the holes in the rear right rail and backing plate. As a result of this misalignment, a screw, right, the rear legs of the ladder were not securely fastened in place, causing the ladder to fail. So this would normally be a good ladder, right? It looks like maybe someone missed a step or something went wrong, right? The jury in that case concluded that this manufacturing defect made the ladder unreasonably dangerous and awarded Schmoody more than $677,000 in damages. All right. The defect is irrelevant if it doesn't make it unreasonably dangerous. I'll just use the over-the-top obvious case, right? But if the defect was that the ladder was painted the wrong color, right? Or that the ladder had cosmetic flaws, right? Those cosmetic flaws wouldn't have been the cause of Schmoody's fall, right? They couldn't have been, right? So unless the wrong paint, right, somehow creates some danger, it's not going to be a proper manufacturing defect. So it's kind of a conflated analysis if you think about what the jury's doing, kind of mashing it together. I mean, if they see a defect, it's truly not a defect if it doesn't cause, from the jury standpoint, unless it causes injury. But there are defects that may not cause injury. Those would be obviously excluded. I'm telling you that because, that's how the fact patterns sometimes are. They'll try to flip, try to take a principle, right? And you'll have all the elements there, and what is missing, right? Sometimes you have to ask yourself, right? If it doesn't quite feel right, what could possibly be missing in this case? So let's say you've got a negligence or a strict liability case that you're analyzing, and these are very short fact patterns. So, but looking at the elements and then looking at the fact pattern, looking at the elements, looking at the fact pattern, you may get a sense that something is missing. One of the things that could be missing is, this is a horribly defective product, but it didn't cause the injury, so it can't be unreasonably dangerous. Or it doesn't create, or the person, misused the product, right? So it can't be unreasonably dangerous. We'll get to that shortly. But a lot of times, because we just did this exercise on understanding how to construct a rule, right? Which is very good work for the most part on that. I'm still kind of working through those at this point. But the point of that really is to make it so that when you look at the fact patterns, right, that you have something to start to begin to sort of ask the question of, is there something missing, or is something else going on here in addition to, or as opposed to maybe my first, stab at what I thought was at issue, maybe it's something else, right? That's why we try to get those gaps in, the generally applicable principles that we use to form our rules. It's a little bit of a digression, but I wanted to bring that up, right? Because in the context of this, the manufacturing test that I'm giving you is fairly simple, right? I'm just saying, look for a product that fails to comply with its specifications, right? It's not as the other ladders should be. It's not how the ladder was designed to be, right? It becomes a little bit more complicated with the design defect. Why? It's it is an attempt to get at what a company should have done, right? And so I've tried to abstract here. It's often not obvious, right? With a design defect, though, we'll know that it's not a manufacturing defect because the product always conforms to its specifications in every salient way, right? With the design defect, we have two main tests that we use, right? One of them is known as the risk utility analysis. This is what we were introduced to in Riley versus Ford Motor Company, which you may want to take another look at. It is case 5.2, right? So this is, in fact, an economic analysis. It is intended to get at the relative worth of two alternative designs. If the plaintiff wins, they will have shown that the reasonable or feasible alternative design that they presented was so much better, right? That the use of the defendant's design, which is alleged to have caused the injury, makes that product unreasonably dangerous. And that is essentially what was found in the Riley versus Ford Motor case. So I'm kind of paraphrasing it. I'm trying to reduce it for the purposes of teaching this. So the other test is the consumer expectations test. And I'll get to that in a second, but basically you have to ask yourself, what would a reasonable user expect? And not to be, well, I'll come back to that in a second, all right? With regard to the risk utility analysis, the Riley case is interesting in that, number one, it was a fairly complicated engineering process. You know, it was a research and design process. And they discovered this in discovery, probably did document requests, certainly did depositions. This is responsive to the prompt for the last video. So if you're watching this before you've answered, there you go. They probably deposed executives and engineers, right? At Ford Motor Company to see, had they ever thought about reasonable alternative design? When they say yes, then they probably sent interrogatories that said, hey, tell us a little bit more about this reasonable alternative design that you discussed in your deposition. And once they learn a little bit more about that, or concurrently, right, because all of this stuff happens sort of concurrently, but you need some information from your litigants, your opposing litigants. So while they're doing this, they're asking for documents that says, show me anything related to the reasonable alternative designs. That would be the document request, right? Do you admit or deny? So you could also go with requests for admissions. Do you admit or deny that you looked at two reasonable alternative designs and that they were within X dollars of one another, and that the alternative actually was more resistant to car crashes, right? That was the analysis that was done in that case. With regard to Riley applied the risk utility analysis. So it's comparing two reasonably alternative designs, right? With regard to the risk utility analysis, it could be a little bit, it's fairly tricky, right? But I think the book does a fairly good job when it talks about the test, right? And it's very simple. Number one, a reasonable alternative design has to be available. And number two, as a result of the defendant's failure to adopt the alternative design, the product was not reasonably safe. That's it, right? But the back work on that was all experts. And so it would not have been an easy case. It's fortunate that the experts, they were able to retain experts who were able to review this engineering data that was supplied by Ford Motor Company. But the prompt for this one, I'd like you to think about, what would you do if you were the attorney and you were going up against something like Ford Motor Company for a similar case? You can assume it's the same facts, right? Except there's no alternative study. Look at the Riley case and see what they did. They were able to get their hands on these alternative studies, these other bits of information for its own work. If you had to prove a design defect, the prompt this time asks you, what would you do to prove a design defect? How would you, as a lawyer, construct a case if Ford didn't do all the work for you, right? But before I close out, I do want to talk about the consumer expectations test. With the consumer expectations test, some courts apply this other test, the consumer expectations test, to determine if the product's design performed in the manner or met the expectations of a reasonable end user, right, or the ordinary customer. So 5.5 case example, Wilson Sporting Goods Company gave Edwin Hickox an umpire's mask that was designed to be safer than other umpire masks. That is the expectation, that it was designed, right? So let's start there, right? This was designed to be safer than the other umpire's mask. The mask had a newly designed throat guard that angled forward instead of extending straight down. While Hickox was working as an umpire during the game and wearing the mask, he was struck by a foul ball and injured. He suffered a concussion and damage to the inner ear, which caused permanent hearing loss. Hickox and his wife sued the manufacturer for product liability based on a defective design and won. They awarded $750 to Hickox and $25 to his wife for having to deal with having lost his hearing. All right. So the mask had a very easy flaw, right? That resulted in the concussion. So while it protected one area, it made another area more vulnerable, right? So it defeated the expectation of the reasonable umpire who's looking for something to protect his noggin, right? And so for that reason, that's why the jury was able to find that way. So those are the two tests that are used to evaluate a design defect: risk utility analysis and the consumer expectations test. We also have the test for a manufacturing defect that it does not conform to its specifications. Respond to the prompt. Let me know what you would do if you were, upon reviewing Riley versus Ford as its attorney, found that Ford, in fact, had nothing for you, right? All it has was its proposed design. What would you do in order to prove that design was weak and not, and basically cost Mr. Riley his life? All right. Thank you very much. I'll see you next time.